Hey, folks. Well, this was unexpected, but also a correct decision by Colorado Appeals Court. Letecia Stauch gets a new trial due to a structural error. Now, a structural error is it's a constitutional defect, as to the degree that they don't even have to analyze it to see would it have been changed the outcome. It is deemed so structural defect that there will be no analysis. It has to be a new trial. So let's talk about it. Welcome to the show. Yeah, this is one of these things that pisses me off. Now, a lot of things do, but this is it's unnecessary. Now, structural errors are so fundamental that they are easily avoidable. It should be apparent to anybody on the judiciary. Don't fucking do it. And yet, the judge made the decision. The state, whatever. And now everybody has to go through it all over again. Letecia Stauch gets a new trial, and Gannon's family has to sit there in the courtroom and relive it again. First, I'm going to show you an article, and then we are going to go into the decision itself. So, Fox 31 wrote about it. Letecia Stauch gets new trial of the murder convictions reversed in Court of Appeals. Stauch was sentenced to life in prison without the possibility of parole in 2023 after a stepson, Gannon, was reported missing from their home near Colorado Springs. Less than 2 months later, his body was found in Florida. She was found guilty on charges of first-degree murder of the deliberation, first-degree murder of a child under 12, by a person in position of trust, tampering with the deceased human body, and tampering with physical evidence. However, the Colorado Court of Appeals announced on Thursday that it was reversing Stauch's convictions and remanding for a new trial after a biased juror was on the case. Eric Sandler, an attorney representing Stauch, argued that her case should be reversed because of a juror. Sandler said a juror had a son-in-law who worked for District Attorney Michael Allen's office, and Allen was the lead prosecutor in the case. This was challenged by the defense team during the juror selection process, but Sandler said the court did not get rid of the juror. The appeals court said, among many other things, we agree that the court committed structural error when it denied Stauch's challenge for cause and a biased juror deliberated. They let a juror in whose son-in-law worked for the lead prosecutor in the case. Now, I have a vague recollection about the challenge during jury selection. Don't know exactly how how they argued and how it went, but the judge didn't find cause. Did not find cause. And back then, didn't give much thought of it. Had I covered that trial today, I would have been up in arms because it is insane. I mean, you have a jury pool of hundreds and hundreds of people, and then, yeah, my son-in-law works for that guy who's the prosecutor over there. Ah! No worries, according to the judge. It's so easily avoidable, folks. It is so insanely easily avoidable. All the judge had to say was, "We'll get another juror." Folks, when it comes to structural error, as I said, it is so fundamental. You don't have to analyze if it would have affected the outcome. Now, in my opinion, had nothing to do with the outcome. It does not matter. The appearance of bias, the chance of bias is enough. Now, this is also a good case to make as an example when it comes to the Murdoch trial, with how the clerk of courts, Becky Boo, acted. The appearance is enough for structural error. And it also pisses me off because this was May 2023, and roughly the same time, we had the Zachariah Anderson trial with all of that absolute bullshit from the prosecutor and either lying or biased witnesses all over the place. And that appeal is still ongoing. So this woman, Letecia Stauch, obviously, every piece of evidence pointed towards her. Every piece of evidence pointed against her. And she gets a new trial due to more moronic decision by the judge. Meanwhile, Zachariah Anderson rots away in prison for something he did not do. Physically impossible that he could have done it. But unless the appeals court finds, yeah, there are error of law in the first instance of appeal, he has to wait for the next set of appeals. And she gets a new trial. And she should get a new trial. Don't get me wrong, Letecia Stauch's rights were violated. It does not matter how guilty every piece of evidence made her out to be. It doesn't matter, and it shouldn't matter. And I feel for Gannon's family sitting through all of that garbage again. If you don't remember, Letecia Stauch defense was not guilty due to reason of insanity. She claimed, what was it? Dissociative identity disorder, former known as split personality disorder. She didn't do it. Some else of her personalities must have done it. She took that poor boy from Colorado to Florida, killed him and hid him in garbage under a bridge. spinster. What's the connection with jury and prosecutor's office? The juror's son-in-law worked for the lead prosecutor in the case. Santa Claus, are you going to leave a lump of coal in the stockings of that judge? Of the judge and the idiot prosecutor. Yes, Angela, I'm going to read the opinion. Do you want to join? If you have time, I'll send Angela a link. Now, I covered this back in the day with Dave, MLS. And we had a lot of fun because it was so stupid. Her defense. Okay, MG Law can't join, but yeah, I'm going to read the summary of the opinion because so as of now, the summary of the opinion is all that has been published. So, but that is plenty. Yeah, that's too close of a relationship. Yeah. Now there are some rumblings around the X that the jury itself at one point in time worked for some kind of law enforcement. So there's multiple, if true, multiple avenues. And such a waste of time with, I mean, hundreds of people in the jury pool and just, let this person stay. All right. Oh, look at that. Christine. Thank you. Now, Christine has been a member for a very long time. One of my first members, I believe, even. But she got her channel deleted, so she can't start over. But thank you so much. Thank you, Christine. Good to have you here. Thank you for your continuous support. All right, folks. The decision itself. And hey, Half-Irish. Thank goodness you're alive. I was searching for somewhere safe to cry. Yeah. My heart goes out to Gannon's family. I mean, if there was an avenue for Gannon's family to sue the prosecutor and the judge, go right ahead. Because it's such an avoidable... It's so avoidable. All they had to do was, oh, your son-in-law works for the guy sitting over there on the prosecutor's office, the lead prosecutor. Yeah, you're gone. That's it. But somehow they found it. Nah, we don't care. And I read that the prosecutor's office was disappointed in the appeals court's decision. You fucktards. You should welcome the Court of Appeals decision and write something of the sort like a HR person. We will see this as an opportunity to learn and an opportunity to grow. All you had to do. Be humble about it. But no, we are so disappointed in that the Court of Appeals didn't allow us to be jack-offs. Yeah, curse words. Yeah, if you need to use curse words yourself, JK Debug has the link to Rumble. So you can make a Rumble account and then they allow a lot more. in the comments in the live chat than YouTube does. Yeah, Vice is up there cursing with. Oh, definitely. Jeff is up there. So many four-letter words. Yeah, I agree. All right, folks, let's. Dun, dun, dun. Dun, dun, dun. Let's see if I can make it a little bit bigger. Yeah. The summaries of the Colorado Court of Appeals published opinions constitute no part of the opinion of the division, but have been prepared by the division for the convenience of the reader. The summaries may not be cited or relied upon as they are not the official language of the division. Any discrepancy between the language in the summary and in the opinion should be resolved in favor of the language in the opinion. So this is the summary. Summary, April 2nd. I do believe they might have waited a day before they published this one. So going forward, who should be recused? The son-in-law or the judge? Well, the son-in-law, I don't know if he still works in the prosecutor's office, but if he does, then there needs to be a new prosecutor on the team prosecuting this case. For the judge itself, by pure embarrassment, he should leave this trial to somebody else. By pure embarrassment. I don't know. It is up to, because now everything starts over. Pre-trial things. So I would imagine that the defense will go for recusal of the prosecutor's team and recusal of the judge. I don't think it will matter in the end, but it would be the right thing to do. All right. People versus Stauch. Criminal law, structural error, waiver, invited error, juries, juror bias, challenges for cause, peremptory challenges. A division of the Court of Appeals considers whether an erroneously denied challenge for cause is waived or invited by virtue of the fact that the defendant does not use a peremptory challenge to remove a biased juror to correct the trial court's error. The majority finds neither waiver nor invited error in this context, and applying People versus that name concludes the error warrants reversal for structural error because a biased juror deliberated. The dissent concludes that the defendant waived the right to claim error on appeal by exhausting all of her peremptory challenges without excusing the biased juror. So it wasn't a unanimous decision. You have one who was wrong, in my opinion. And judgment reversed and case remanded with directions, which means that with direction basically means, yeah, you need to do the trial again. Here are some directions. Here are some directions to avoid this crap again. Dun, dun, dun. Defendant Letecia Stauch appeals the judgment on conviction entered after a jury found her guilty of first-degree murder after deliberation, first-degree murder of a child under 12 by one in a position of trust, tampering with the deceased body, tampering with physical evidence, a multiple crime of violence sentence enhancers. Because we conclude that the trial court committed structural error by denying Stauch's challenge for cause to a biased juror who deliberated, we reverse the convictions and remand for a new trial. Background. The prosecution presented evidence at trial that Stauch brutally ended her 11-year-old stepson, Gannon, in Colorado, put his body in a suitcase and left it underneath a bridge in Florida. Stauch had pled not guilty by reason of insanity, arguing that she suffered from dissociative identity disorder. But the jury rejected that defense and found her guilty as charged. The trial court sentenced Stauch to life imprisonment without the possibility of parole, plus 2 consecutive sentences for the 2 tampering convictions. On appeal, Stauch claims the court committed structural error when it denied her challenge for cause to a biased prospective juror who then deliberated. She also asserts the court erred by denying her request to suppress evidence obtained pursuant to an overbroad warrant, and by admitting certain testimony by her ex-husband, Gannon's father. We agree that the court committed structural error when it denied Stauch's challenge for cause and a biased juror deliberated. As a result, her convictions must be reversed. Because it is likely to arise on remand, we also consider and reject Stauch's Fourth Amendment challenge to the search warrant. However, we do not reach the remaining evidentiary issue. Challenge for cause. Applicable law. Section 1610-1031 provides that a trial court shall sustain a challenge for cause on one or more of the following grounds: relationship within the third degree by blood, adoption, or marriage to a defendant or to any attorney of record or attorney engaged in the trial of the case. Within the third degree. It was a son-in-law. Or marriage. It's in plain fucking language what to do here. And the state and the judge failed. The existence of a state of mind in the juror, evincing enmity or bias towards the defendant or the state, unless the court is satisfied from the examination of the juror or from other evidence that he will render an impartial verdict according to the law and the evidence submitted to the jury at trial. Jurors who fall within one of these categories are considered biased as a matter of law, impliedly biased under subsection 1b, and actually biased under subsection 1j unless they can be rehabilitated. Upon a challenge for cause, the trial court is required to excuse them because, except as described in subsection 1j, they cannot be rehabilitated. In People versus McRander, the Supreme Court held that when an elected district attorney is the attorney of record, section 1610-1031b includes prospective jurors who are related not only to the elected district attorney, but also to any deputy district attorney in that office at the time jury selection occurs. That is, the statute directs automatic removal of a juror related within the third degree to any deputy district attorney in the elected district attorney of record's office, regardless of whether the deputy district attorney appeared or participated in the case. This preserves the appearance, if not the reality, of fairness in a criminal prosecution and public trust and confidence in the criminal justice system. When a trial court erroneously denies a challenge for cause and a biased juror serves on the jury, the error is structural and requires reversal. As part of voir dire, the prospective jurors completed a questionnaire that included a question about whether they had friends or relatives in law enforcement. Prospective juror MB indicated that his son-in-law worked with the El Paso County District Attorney. During follow-up questioning, juror confirmed that his son-in-law worked as a deputy district attorney in the same office as and for Michael Allen, the elected district attorney in El Paso County and the prosecuting attorney in this case. Hold on. How the fuck do you get a tick, Mr. Jingles? It is cold as fuck outside, and you managed to get a tick? Now, go down, and I'll handle that later. Sorry, folks. Here it is, in plain language. His son-in-law worked as a DDA in the same office as the elected district attorney and the prosecuting attorney in this case. Plain fucking language. Defense counsel later identified juror among the prospective jurors he wished to challenge for cause. When the court asked for more detail, the judge said, "Oh, why?" Defense counsel explained, "His son-in-law works for Mr. Allen." The prosecutor in court then made the following comments. Prosecutor, I hate to agree with defense counsel, but the follow-up questions were never asked. How that's going to impact his ability to be a fair and impartial juror. And that certainly doesn't rise to a level of statutory cause, so we would object to him being released for cause. Idiot! Court. Yeah, I'm going to circle back to that one too. Probably what I'm going to do is not excuse juror at this point in time and think about it over the weekend and see where we are. I tend to agree that I don't think it's a statutory cause, and I didn't hear anything else about the fact creating an issue or conflict or something else. I don't run across those sets of facts very often, so I just need to think about that one, and it may be that I decide it next week. Let's go up and look at this again. Relationship within the third degree by blood adoption or marriage to a defendant or any attorney of record or attorney engaged in the trial of the cause. The juror's son-in-law was a DDA working directly under the prosecutor in this case. It's plain fucking language. Idiots. The prosecutor suggested that the court ask further questions of juror, and the court agreed. Defense counsel objected. I think the record is what it is. And I guess the only thing I think that there is, a difference between somebody saying, I have a son or daughter who works for the police, then I have a son-in-law who works for the DA, who is actually trying the case. So I think that's where it becomes different. Even if it was a different DA, other than his son-in-law's direct boss, who is trying the case, I think it would be different, and I leave it on that. Yeah. Even if it were one step further away, it would still be a structural error. The trial court brought the prospective jurors back into the room and asked juror how long his son-in-law had worked for the DA. Where a juror had discussed the case with his son-in-law does not fucking matter. Whether juror might be influenced by a desire to have the case work out better for his son-in-law. Based on his answers, the court instructed juror to return the next day. He was not ultimately dismissed. This is a strong contender for you can't unfuck a clusterfuck of the year. And we are in April. Discussion. The Attorney General does not dispute the juror fell within the category described by Section 1610(103)(1)b because he was related within the third degree to his son-in-law, who was the DDA in the prosecuting district attorney's office. We are bound by the Supreme Court's determination that his bias was implied by law. McRander case. Yeah. Nevertheless, the AG, Attorney General, argues that reversal is not warranted because it's not clear from the record whether juror deliberated. The Attorney General also asserted that the defense counsel challenge for cause was not properly preserved. That counsel either waived or invited the trial court's error. We are not persuaded by these arguments, says the appeals court. Yeah. The AG actually argued that the defense attorney invited the trial court's error. It's I, our review of the record demonstrates that jury deliberated. Indeed, the trial court granted Stauch's motion to settle the record on this point, removing any doubt. Footnote 1. While the Attorney General attempts to dismiss this portion of the record as new material, the trial court's order settling the record was accepted as part of the supplemental record on appeal. It is therefore properly before us. The Attorney General first argues that Stauch failed to properly preserve her challenge for cause because counsel did not explicitly cite Section 1610-103(1)b and did not correct the trial court's purported misunderstanding that the challenge for cause was based on something other than a statutory ground. The Attorney General further asserts that defense counsel's comments after making the challenge for cause suggest that the challenge was based on jurors' actual bias subject to rehabilitation, not his implied bias based on his relationship to the prosecutor. For the reasons discussed below, we conclude that the court considered and ruled on a statutory challenge for cause under 1610-103(1)b. Therefore, the challenge is properly before us. Footnote 2. The Attorney General frames their argument in terms of preservation, which directs our standard of reversal. But structural error generally requires automatic reversal without regard to whether the error was preserved. Nonetheless, in order for us to review the erroneous denial of a challenge for cause must have been made. To begin, we recognize that the defense counsel's challenge for cause potentially implicated two different subsections of Section 1610-103. Recall that the statute requires the court to sustain a challenge for cause on one or more grounds, including implied bias based on a relationship to an attorney of record, subsection 1b, and actual bias subject to rehabilitation, subsection 1j. That is, defense counsel could have based his challenge on jurors' relationship to the prosecutor or his state of mind resulting from that relationship. Given this context, we reach two conclusions from the record. First, we conclude that counsel's stated reason, his son-in-law works for Mr. Allen, was sufficient to trigger a ruling under subsection 1b. Second, even if it were not clear solely from counsel's challenge to juror on which part of the statute counsel was relying, we nevertheless conclude the prosecutors and court's subsequent comments brought subsection 1b squarely into play for purposes of our review. This is excellent because if it was ever any doubt, Mr. Gingles, you have a tick. I will take care of it. My cat, Mr. Jingles, managed in freezing degree weather to find the one place with a tick. Now I have the things for it, but I'll take care of it. I'll take care of it. Yeah, it is crazy. It is terrible. It is. Yeah. In the trial itself, I have no issues with this judge. He made, to my recollection, I did not have a problem with either of his rulings back when I covered this trial back in 2023. Not to my recollection, at least. And if I had, it was probably minor. But this, it's yeah, it's plain language Wrong. As the prosecutor correctly observed at the time of the challenge, neither attorney had asked any questions to elicit whether the juror had a state of mind, evincing enmity or bias. Without these questions, there was no way to tell whether the juror should be excused for actual bias under subsection 16.10.103.1j. Having recognized this, the prosecutor continued to note that the challenge certainly didn't rise to a level of statutory cause. In this context, we conclude the prosecutor could only have been referring to statutory cause based on implied bias under subsection 1b. Hi, Derek. This is Colorado v. Letecia Stauch, who killed her stepson in 2020, was convicted of it in 2023 after she raised not guilty by reason of insanity, blaming dissociative identity disorder. The trial court's subsequent comments likewise suggest its awareness of the distinct four cause challenges available under subsection 1b and 1j. The court first said, "I don't think it's a statutory case," and then noted that it didn't hear anything else about the fact creating an issue or conflict or something else. Mr. Jingles, sorry, hold on, folks. I need to take care of Mr. Jingles' tick because he's not going anywhere. I'll be right back. Come. Yeah, I had one of these anti-tick squirty thing that you put in the neck, and he was so happy to receive it. Now he doesn't. Yeah. sorry, I had to take care of that because, yeah, and it's one of these things that anti things. So now it will take care of fleas, ticks, and worms. So it will now. So tomorrow I have to go through his litter box to see, okay, any worms? Things they never tell you when you take care of abandoned cats. Okay. Thank you. Thank you. Mr. Jingles, at the moment, does not agree. Hi, Cindy, just getting online, and what the hell is this? Yeah, it is a structural error by trial court. Easily avoidable. Easily avoidable. Fleas, ticks, and worms sounds like a new earth wind. Oh, I sense a suno-song coming about. Yeah, all right. Let's continue. These comments indicate a cursory and improper reaction of a challenge based on the relationship itself under subsection 1b. For you who just joined, yeah, the juror's son-in-law was a DDA working directly under the prosecutor in this case. And somehow the judge didn't find this weird. Whereas Dave haven't. I sent it to Dave, and Dave has an invite as well. So if he doesn't know, he will know soon. Followed by separate consideration and reaction of a challenge based on a biased state of mind under subsection 1J. Despite the Attorney General's arguments, we do not read these statements as demonstrating confusion about the nature of defense counsel's challenge. Instead, read in context, we conclude that trial court statements, "I don't think it's a statutory case," reflects the court's mistaken belief that jurors' implied bias based on his relationship to the prosecutor, as distinct from his actual bias as a result of that relationship, did not trigger mandatory removal under subsection 1610-103-1b. In other words, the trial court was not questioning whether defense counsel was making a statutory challenge for cause based on the relationship itself. Instead, and critically for purposes of our review, we read the trial court statement as expression its inclination to deny the challenge for cause on both grounds. Oh, lol, miss. The court should craft a remedy where one of the attorneys form the defense team's firm to get to be a deliberating jury for the treat. No, I don't think so. Grounds. Oh. When the trial court ruled on the claim raised on appeal, it is properly before us. People versus McPhee. Defense counsel's subsequent argument that the situation might be different if the jury's son-in-law worked for the police or for a different district attorney other than his direct boss who is trying the case does not change the result. As the Attorney General acknowledges, that argument went to whether juror should be excused for actual bias under subsection 1610-103-1J. And the trial court had already rejected the challenge under section 1610-103-1B. As a result, defense counsel was under no further obligation to restate his objection. And there was a footnote 3 here. The record further supports this reading. In addition to juror, defense counsel identified juror number 8 among the jurors he wished to challenge for cause. He explained that juror number 8 had indicated on his questionnaire that he could not be fair in a case involving child abuse, was not sure he could set aside the information he had heard about the case, believed the not guilty by reason of insanity plea was a ploy to excuse the alleged crime, and was never asked about any of that. By contrast, when asked for his basis for challenging juror for cause, defense counsel simply said, yeah, his son-in-law works for Mr. Allen. JKD Buck. Yeah, what happens to the judge apart from being a laughing stock? Nothing. Nothing. And thank you for the super sticker. Thank you for the super sticker. Which is a lemon throwing kisses. Oh, thank you so much. Thank you, Derek. That is so nice of you. Thank you so much for your support. Thank you. Likewise, that defense counsel did not cite 1610-103 is of no moment. The Attorney General relies on People v. Cavallos-Acosta, in which a division of this court declined to consider denial of a challenge for cause because defense counsel did not specifically cite section 1610-103-1K. But in Cavallos-Acosta, quote, defense counsel moved to challenge the juror for cause because he would place authority on the testimony of a police officer over anybody else, not based on the mere existence of a relationship covered by the statute. This case is distinguishable. Defense counsel's initial challenge for cause succinctly stated that juror was related to the prosecutor. Unlike in Ceballos-Acosta, counsel did not argue that juror might have actual bias in favor of the prosecution. And as discussed, even if defense counsel's comments left any doubt, the prosecutor and trial court expressly acknowledged and dismissed the possibility of a statutory challenge based on the relationship itself. On these facts, we conclude the trial court was on notice on the particular ground for the challenge, even without a specific reference to section 1610-103-1B. The error was neither waived nor invited. Well, this will be interesting. Waiver is the intentional relinquishment of a known right or privilege. We indulge every reasonable presumption against it. This is the appeals court telling the Attorney General, really? Invited error, by contrast, prevents a party from complaining on appeal of an error that the party invited or injected into the case. It is, quote, is a narrow doctrine and applies to errors in trial strategy, but not to errors that results from oversight, end quote. The Attorney General asserts that defense counsel waived or invited the trial court's error by failing to clarify the basis of the challenge after the ruling suggesting that the court was confused about the grounds for the challenge. But we have already concluded that the trial court's comments did not indicate that it misunderstood the nature of the challenge of a cause, only that it did not believe excusal was warranted. Given this reading of the record, the foundation of the Attorney General's waiver-invited error argument collapses. In any event, even after juror answered the trial court's follow-up questions, defense counsel said, I maintain my objection. This ongoing objection suggests there was no waiver. Nor can we conclude that defense counsel waived or invited the error by failing to use a peremptory challenge to excuse the juror. The law does not require criminal defendants to use peremptory challenges to preserve an unsuccessful challenge for cause. To the contrary, the Supreme Court has held that its, quote, prior decisions do not require a defendant to cure a trial judge's error or a challenge for cause by using peremptory strike against the objectionable juror in order to preserve a claim that his right to a fair trial was violated by the presence of a biased juror. and want to, yeah. These cases indicate that there is no inherent inconsistency in allowing counsel to challenge a juror for cause, while also permitting her to use peremptory challenges to excuse other jurors. We recognize that the majority in this case declined to consider whether waiver or invited error might apply in such a situation because it was not raised on appeal. Nevertheless, the majority suggested, albeit in dicta, they indicated that even if it were to entertain an invited error argument, it would find no invited error because the record did not suggest that the defense counsel purposely failed to use a peremptory challenge to remove the impliedly biased juror. Similarly, we see no suggestion of invited error here. And particularly in light of defense counsel's ongoing objection, we see no suggestion of waiver on the record. The Attorney General relies on Justice Samour's dissent in that case, expressing that defense counsel's decision not to use a peremptory challenge to excuse a juror after the loss of a for-cause challenge is a classic example of waiver or invited error. Like Justice Samour, the Attorney General suggests that counsel may simply request, and trial courts may be encouraged to grant, an additional peremptory challenge. But as in that case, the record here lacks any indication that the counsel was acting strategically, finding no invited error under the same circumstances. Additionally, we are not persuaded that defense counsel should be required to use a peremptory challenge to excuse a biased juror after the court erroneously denies a for-cause challenge. They are quoting the same case as the Attorney General. Moreover, nothing prevents the prosecution from using a peremptory challenge to remove a juror who should be excused for cause. Yeah. The state could have said, yeah. Or, in this case, Mr. Allen, the lead prosecutor and the elected district attorney, should have and could have said, yeah, that juror's son-in-law is working directly under me. I don't think that is good. So it works both ways, Attorney General. Nor are we persuaded that defense counsel may re-level the playing field simply by requesting an additional peremptory challenge. Our Supreme Court has consistently recognized the type of error implicated here, a violation of the defendant's rights to an unbiased jury as so harmful that it warrants automatic reversal. See, People v. Flockhart, structural errors require automatic reversal without individualized analysis on how the error impairs the reliability of the judgment of conviction. Meaning, you don't have to analyze it. You have to, that's the juror's relative works for the prosecution. Boom, gone. Should be as easy as that. The harm arising from an biased adjudicator pervades and infects the entire framework of the trial. Meaning, it does not matter. The outcome or possible outcome of the trial has no relevance in this. None whatsoever. And because maintaining the integrity of the judicial process is in the interest not only of the accused but of the public, we are not inclined to infer waiver from defense counsel's failure to use a peremptory challenge to correct the trial court's error. Reversal is required. When the trial court erroneously denies a for-cause challenge to a biased juror, the defendant exhausts her peremptory challenges and the biased juror serves on the jury. The error is structural. The result of the legislature's determination that certain relationships render a potential juror impliedly biased is that the juror is deemed as a matter of law to be biased period. Such is the case here. Accordingly, Stauch's convictions must be reversed. And it's plain language. And this is a summary. The actual opinion from the appeals court will probably be a bit longer. But as a summary, this is a very, very short summary. Extremely short, because it is so clear to the appeals court that the judge made a horrifyingly bad decision in not saying, yeah, off you fuck. The state not doing it themselves. Also, it's so easily. It's so yeah, this looks bad. Off you fuck. That's all they needed. Easily avoidable. And now they have to do it all again. They have to do it all again. And as of this decision, Letecia Stauch, as a matter of law, is innocent until proven guilty in a court of law. Until and unless. And we don't know what the next trial will go, how the next trial will go. Well, the facts are still the same, but with a new judge and a new prosecutor, and maybe even a new defense team, we don't know what the rulings will be. Because they start from zero. Now they are going into the search warrant. Stauch also challenges the court's denial of a motion to suppress evidence obtained from a search of a cell phone. Oh yeah, her text messages, her Google searches. Holy fuck. Oh, I vaguely remember it was so bad. It was perhaps worse than the Corey Richards Google searches. Because this issue is likely to impact the proceedings on remand, we elect to address it. In denying Stauch's motion to suppress, the trial court acknowledged that the warrant to search Stauch's cell phone was broad, but concluded that its breadth was necessary, given the scope of Stauch's conduct after Gannon went missing. Stauch argues the court erred, but because the warrant violated the Fourth Amendment particularly requirement. We discern no error, meaning, yeah, we don't see any flaws with it. Applicable law. The Fourth Amendment protects individuals against unreasonable searches and seizures. A search conducted pursuant to a warrant is typically reasonable. However, so-called general warrants, which permit a general exploratory rummaging in a person's belongings, are prohibited. To prevent a general exploratory search, a search warrant must be sufficiently particular as to enable the executing officer to reasonably ascertain and identify the things to be searched. Because cell phones contain so many different types of private data, warrants to search them must be carefully scrutinized. To be sufficiently particularized, warrants for the search of data on cell phones must include specific limitations based on the type of alleged criminal activity, the identity of the alleged victim, and the time frame, if applicable, within which the suspected crime occurred. I was raided? I don't see a raid. If I was recently raided, thank you. Good to have you here. Welcome to the show, and protect your ears if you are sensitive for cursing, because this is fucked up. Hi. Oh, Squid Pro Co raided. Thank you, Squid Pro Co. Thank you. Squid raid. When evaluating whether a warrant is sufficiently particular, we must look at the totality of the circumstances, reviewing the warrant and any accompanying affidavits in a practical, common sense fashion to determine if probable cause exists. Even if a warrant lacks particularity on its face, An affidavit submitted in support of the warrant may cure its lack of particularity if the deficient warrant incorporates the curative affidavit by reference. Both documents are presented to the issuing judge or magistrate, and the curative affidavit accompanies the warrant during the execution of the warrant. A trial court suppression order presents a mixed question of facts and law. We accept the court's finding of fact if they are supported by competent evidence, but we assess its legal conclusion de novo, meaning as a completely new issue. Hello, Squid Radius. Welcome, welcome, welcome. Additional facts. The investigating detective sought a warrant to search Stauch's cell phone for the following: data that may identify the owner or user of the devices, address books and calendars, audio and video clips related to the above described criminal activity and further described in this affidavit in support of the search warrant, call histories, call logs, and visual voicemail related to the above described criminal activity and further described in this affidavit in support of the search warrant, photographs and associated metadata related to the above described criminal activity and further described in this affidavit in support of the search warrant, text messages, multimedia messages, recorded messages, and subscriber information modules between the cell phone owner and co-conspirators involved in the above described criminal activity and further described in this affidavit in support, blah, blah, blah. Email, messages, and attachments. Browser files including but not limited to browser history, browser cache, stored cookies, browser favorites, autocomplete form history, and stored passwords. I don't like this one because autocomplete is only partially what can only show partially what the owner of the cell phone is actually searching for. And it's very, very easy to just write the first three words. You don't see that, oh, it auto-completed. You press enter and all of a sudden you get results that you were not actually looking for. So that I do not agree with. GPS data, documents, apps, and then software. Any and all data stored within a computer storage device. With respect to these items, the warrant authorizes police, with the aid of a law enforcement computer forensic laboratory, to view, photograph, record, copy, forensically image, and conduct forensic analysis of any and all metadata, programs, and applications on the above described devices, as well as on any data storage devices and or mediums attached or installed in these devices. The warrant incorporated an affidavit detailing Gannon's disappearance and Stauch's conduct thereafter, including Stauch's refusal to cooperate with police, conflicting statements and behavior, ongoing communication with family members, and social media posts. The affiant submitted that it was necessary to search Stauch's cell phone to ascertain her past location and communications and to aid in locating Gannon, who was still missing at the time. Yeah, poor Mo. This case was hard on Mo. And finding this out, oh, poor Mo. Discussion. Stauch argues that the warrant to search her cell phone was overbroad because it allowed police to access anything that might be on her phone with no temporal limitations. While she acknowledges that the affidavit was incorporated by reference into the warrant, she argues that it broadened the scope of the search even further by allowing a search for anything that could be used as evidence against her. We disagree. True, the warrant itself did not describe the type of alleged criminal activity, identity of the victim, or time frame within which the crime occurred, but it specifically incorporated the warrant application and supporting affidavits that did. The warrant limited the search to the items specified in the application, and the application in turn attached the 4-page supporting affidavit and made it part hereof. The affidavit described how, on January 27th, 2020, Stauch called to report Gannon missing. stating that he had left her house on foot and had not returned. It continued to describe how, during the subsequent 40-hour period, Stauch refused to meet with police or provide requested information, was unaccounted for during the part of the day Gannon was reported missing, calling sick for work for an unrelated reason, and had been continuously communicating with the daughter, husband, and other family members via text messages and Facebook. Yeah, Letecia Stauch changed her story so many times it was ridiculous. And her defense to that was, well, dissociative identity disorder. The defense tried to claim that the change in her story was because her other personalities was in charge of her. Yeah, it but I remember that those other personalities didn't show up until she was faced with, yeah, you're lying. Gail Judkins became a member. Thank you so much. That is welcome to the Viking crew. Welcome to the Viking crew. And now you have access to all my members only content. You will have access to my videos before anybody else. And you will have your own emojis here on YouTube's. The affidavit also described that Stauch met with police 2 days after the report, and she substantially changed her statement regarding Gannon's disappearance. Stauch initially suggested Gannon went to a friend's house and didn't return. But at the police station, she said he was abducted by a carpet repair person who had sexually assaulted her at gunpoint. The affidavit went on to describe a roll of carpet with blood on it that was found in a storage area inside Stauch's house. It also stated that Stauch's cell phone was linked to a doorbell camera security system. Based on its specific incorporation of the affidavit, which was signed by the issuing magistrate and accompanied the search warrant during its execution, we conclude that the warrant was sufficiently particular. Stauch argues otherwise based on the Coke case, in which the court found the warrant was insufficiently particular because it contained no limitation as to the alleged victim or time period during which the crimes occurred. But as described above, the warrant and affidavit here specifically described Stauch's conduct during the 40-hour period after Gannon went missing. While the warrant was broad, the affidavit was specific. It described conduct limited to those 40 hours, clearly identified Gannon as the victim, and detailed inconsistencies in Stauch's conduct and story in the aftermath of his disappearance. The fact that a warrant was broad was not dispositive. When it covered a 6-month period, the affidavit identified the victims and specified crimes, and the defendant's conduct and communications surrounding the crimes were relevant to identifying him as the suspect. This is from the Rodriguez-Ortiz case. Moreover, many of the categories described in the warrant were expressly limited to items related to the above-described criminal activity and further described in this affidavit. While not every category included the same limiting language, the warrant's incorporation of the attached affidavit served the same function. Warrant satisfied particularity requirement on this basis, even if it could have been more particular. Because the warrant and affidavit, read together, limited the search of Stauch's cell phone to a specific time frame, victim, and type of criminal activity, the warrant did not allow for a general search. Instead, it targeted a specific set of data that allowed police to establish Stauch as a suspect. We therefore conclude that the Fourth Amendment particularity requirement was satisfied, and Stauch's motion to suppress was properly denied. Disposition. The judgment is reversed, and the case is remanded with directions. Judge Gomez concurs. Judge Bernard concurring in part and dissenting in part. Assume a court, this is Judge Bernard. Assume a court erroneously denies the defendant's challenge for cause to a hypothetical juror A. Then assume the court also denies the defendant's challenges for cause to hypothetical jurors B, C, D, E, F, G, and H. Next, assume the defendant has 16 peremptory challenges. She uses 7 of those peremptory challenges to remove jurors B, C, D, E, F, G, and H from the jury, and the other 9 challenges to remove prospective jurors from whom she did not challenge for cause. But she does remove juror A, who sits on the jury that ultimately convicts her. In this situation, does she waive her right to contend she is entitled to a new trial because of the court's error? I would answer this question yes, because the majority answers this question no. I respectfully dissent from the portion of Part 3C3 to C3 of the majority's opinion, concluding defendant Letecia Stauch did not waive the error the trial court made when it denied her challenge for cause to juror MB. I concur with the majority determination in Part 2C3 that the court erred when it denied that challenge, and with the majority's analysis of the Fourth Amendment issue in Part 3C. Okay, so this Judge Bernard dissenting, not because he disagreed, him or her, disagreed, wanted to go further. That's the dissent here. He wanted to go further. So that's positive. I also addressed the issue the majority does not discuss. Did the trial court err when it allowed the prosecution to present evidence concerning the defendant's prior manipulative behavior to rebut her defense of not guilty by reason of insanity? Because I do not believe the court erred. I would affirm defendant's convictions. Huh? How can you agree with the majority decision of basically an structural error, but still affirm the convictions? I don't get it. This is counterproductive. Structural errors, even those impinging on fundamental constitutional rights, can be waived. Blah, blah, blah. Waiver is the intentional relinquishment of a known right. When deciding whether a waiver was implied, the record need only show that a defendant or her counsel made a conscious decision to forego raising a claim or an objection for strategic or for other reason. Bum, bum, bum. I need to... This is long. Yeah, I'm a quick reader. I'm not entirely sure how this judge came to its conclusion with this. Okay. Still, despite... She waived the error because she did not remove juror MB with a peremptory challenge, although she has 16 available to use for that purpose. But that's not what half of this judge is basing is not case law. It is dissenting opinions or concurring opinions with additional information. So I don't. Well, I don't get it. Somebody more affluent. No, Smushy, not the phone. The phone search. The appeal court says no. That's not good enough. The reason is structural error, that the court allowed a juror in whose son-in-law worked in the DA's office directly under the prosecutor in this case. That is why they made it an automatic reversal. Okay, unlike in this case, the prosecution raised the issue of waiver in the answer brief in this appeal. Yeah. But the defense attorney, yeah, I'll renew my objection. It is preserved. The issue has not been decided in Colorado. Martinez Salazar only applies to federal cases. Morrison did not resolve the issue either. Supreme Court stated it need not base its decision on how the defendant responded to what he perceived to be an erroneous denial of challenge for cause. The court also said it is unnecessary to determine whether the defendant suffers an impairment of his rights to use peremptory challenges if he exhausts his peremptory challenges, but not use one of his challenges against the juror who he originally challenged for cause. Yeah, I'm not entirely sure. As you can see here, Morrison was decided 14 years before Novotny, so as an artifact of the era of the automatic reversal rule, it is unclear how much Morrison's reasoning is still viable, since it was rooted in that now discarded rule. And the Novotny, but they are not using the Novotny case. They are using the Morrison case as a baseline of their decision, meaning that the majority says Novotny is not applicable to this specific case, and then Morrison kicks in instead. Requiring parties to use peremptory challenges to cure jury selection errors is a good idea whose time has come in Colorado. No. So this judge seems to be under the impression that it's not necessary for the court to remove a juror for cause, even though the law itself specifically says you have to. Because the defense, they have this peremptory challenge. Yeah, then you will force the defense to use a peremptory challenge for something they shouldn't need to. I'm not entirely sure how this is good, because it forces the defense to unnecessarily use peremptory challenges they might need for another juror. So I don't think this is a good idea at all. So if a defense attorney waives an error related to a challenge caused by not making the challenge in the first place, or if the attorney waives the same type of error by not exhausting the peremptory challenges allotted to the defendant, how does that same lawyer preserve the error by making the challenge for cause, having it erroneously denied, and then failing to remove their juror with an available peremptory challenge? Because they are not supposed to need to. They might have, it doesn't really matter how many they have left if the judge already said, no, I'm not going to do this for cause, because then they might waste a peremptory challenge on something that might be needed later. So why would... I mean, this judge's dissenting on that issue is almost longer than... I conclude this combination of awareness and deliberate conduct was intentional, and it was an implied waiver of defendant's right to challenge the trial court's erroneous decision to deny her challenge for cause to juror on appeal. Defendant could have cured the trial court's error, but through her counsel, she engaged in conduct that manifested an intent to relinquish the right to remove jury from the jury. But seriously, Judge, I don't forget the name here. You're putting all the blame on the defense for something that shouldn't even have been brought by either side. The judge should have just read the jury. Oh, you're related to a DDA in that guy's office. Yeah, fuck off. Instead, this appeal court judge puts all the blame on the defense. Well, and then now I know to the remaining appellate issues, the majority does not address. Now, this is interesting. Why? Testimony about manipulative behavior. The defendant asserts the trial court erred by allowing the prosecution to rebut her insanity defense by introducing evidence showing she had previously been manipulative. I disagree. Defendant objected to this evidence, adding the court should analyze it under CRE 404B. The prosecution replied that the evidence was relevant to the defendant's mental condition. The court decided 404B did not apply. I will assume for the purposes of discussion, the manipulation evidence was a form of bad act evidence. Yet I would nonetheless conclude the court did not err when it admitted it. Now this, in my opinion, this judge is trying to cure for the state by addressing things that the rest of them said. It's no longer necessary to address this. We already concluded on the two main topics, the warrant and the juror, that, yeah, reversal. The rest is up to the court to do again. Here, this judge says, yeah, this next judge more or less has to let this in. So this judge, in my opinion, makes the argument that the next trial, the trial judge has no discretion in this matter. I don't think this is fair. Before Colorado switched its present unitary trial system, the law bifurcated sanity and guilt trials when defendants pled not guilty by reason of insanity. Generally, evidence of prior criminality of an accused is not admissible. However, in a bifurcated insanity trial, this rule is relaxed, since the prejudice that may occur by the admission of such evidence is lessened by a separate trial on the issue of guilt. Courts in other states have decided that defendants, by pleading not guilty by reason of insanity, makes much of their entire life history relevant. I therefore conclude the evidence of defendant's manipulation would throw light one way or the other on the issue of defendant's sanity, and that it would strain the rules of evidence to hold that the prosecution is precluded from introducing evidence to counter a defendant's claim of insanity solely because the evidence involves the defendant's previous immoral or unlawful conduct. Huh? But what if this reasoning does not apply to Colorado's present unitary trial system? Even if I thought the trial court's decision not to apply 404B was error, I don't think it's reversible error. A conviction will not be overturned on appeal when the trial court used an erroneous standard in analyzing the admissibility of evidence if the evidence was admissible and the proper foundation was laid for its admission. The record supports the determination the manipulation evidence was admissible under 404B and under the four-step test announced in People v. Spoto. The evidence related to the material fact of whether the prosecution could prove beyond a reasonable doubt the defendant was sane at the time of the crime was logically relevant to this material fact because it provided a basis for testimony that some of the defendant's conduct was manipulative, meaning she was malingering the claim of mental disease or defect. Had logical relevance, independent of the prohibited inference that defendants committed a crime on account of a bad character because it gave the jury information with which to assess the validity of her insanity defense and had probative value that was not substantially outweighed by the danger of unfair prejudice, see 403, because defendant's manipulativeness did not have an undue tendency to suggest a decision on an improper basis, commonly but not necessarily an emotional one, such as sympathy, hatred, contempt, retribution, or horror. Accordingly, I would affirm defendant's convictions. And that was... So this judge who chooses to dissent from the majority's decision not only did that, but also with this written opinion gave the next trial, in this specific issue regarding prior bad acts from defendant, more or less gave the judge an order to let it in. So someone tells the judge, this is an opinion, not a journal. He's just talking to himself now. Yeah, I'm not a fan of the... I mean, I've read dissenting opinions before. Majority of them, if not an absolute majority of them, still leaves to the judge's discretion on how to rule. In this dissent, I don't see this judge giving the judge the chance of discretion in this specific issue. That's well, let's see here. It's a dissent, it can't order anything. Dissents are equally binding from a judge. They have zero force of law. Yeah, I agree with the creed here. Yeah, it's a dissent. It has no... it's not case law. It cannot force. The judge may still have discretion. I agree. My wording is a bit off there. But it still makes the implied suggestion that the court should let this in. And for me, I'm not a fan of it. Because, yeah, my opinion as a YouTuber with a law degree has absolutely no bearing on what the judge the trial judge does. This is the Court of Appeals. Their opinions have weight. So, but as Creed says, yeah, a dissent can't order anything. Completely correct. But in the People versus Stauch, structural error, the majority decided that allowing a juror to stay as a juror despite their son-in-law being a DDA working directly under the prosecutor on this case to stay as a juror, it's a correct decision. It is, and it's infuriating, as I said earlier, because it would have been so easy. Yeah, we don't need you. We have 80 to 100 other jurors. We can pick one of those. It's so easily avoidable. And now they have to go through it all again. Gannon's family has to sit in court and see the medical examiner's photos. They have to see it all again. This should have been behind them. They should have been in a state of healing, knowing that Letecia will never get out of prison. And now, by law, she is innocent until and unless proven otherwise. It's unnecessary. But the appeals court made the right decision because the rules have to apply to the worst of the worst, as Letecia Stauch. Because if we bend the rules because she's a really horrifyingly evil person, then the rules are bent for everybody else. And we can't have that. We can't have that. Folks, it seems like we have to cover this fucking trial all over again. And I will. I covered it 3 years ago, and I will cover it when it comes back. So, folks, thank you. Thank you for listening in. From me and Mr. Jingles, you all have a... Yeah, folks, thank you first of all. Thank you for showing up. It is thanks to you guys that this channel keeps going. Thank you for Christine for continuing to be a member. Thank you to Derek for your super sticker. And thank you to Gail Judkins for becoming a member. Thank you so much. Tomorrow, it's Friday, what we call Long Friday over here. Not sure if I will stream anything tomorrow. I probably will. But the rest of Easter, I'm gone. I might have a short form video or something just to have something to post because that's the YouTube ergo. Again, thank you. Thank you. And yeah, I will see you all in the next stream or video. And remember, folks, hug your family. Unless they're shit, then screw them and give your love to the people who deserve it. Bye-bye.
Waves, brothers, axes high. England.